And now it's time for another case law update. Today, we're diving into a topic that has received renewed attention lately: the concept of force majeure and how it applies in Texas energy contracts. While not all of these cases are hot off the press, each one offers essential lessons that are particularly relevant in the current climate of commodity price swings and operational uncertainty. The first two cases illustrate how Texas courts handle force majeure claims tied to economic downturns, while the third case deals with force majeure claims and internal error. In Valero Transmission Company versus Mitchell Energy Corp., before the First Circuit Court of Appeals in Houston, Valero sought to avoid its obligations under a gas purchase agreement by invoking a force majeure clause after market conditions shifted and made the contract financially unfavorable. But the court was clear. Just because a contract becomes more expensive to perform doesn't mean performance is excused. The force majeure clause in question did not specifically enumerate economic conditions or market fluctuations, and the court emphasized that market downturns are foreseeable as a matter of law. In the court's own words, an economic downturn in the market for a product is not such an unforeseeable occurrence that would justify application of the force majeure provision, and a contractual obligation cannot be avoided simply because performance has become more economically burdensome than a party anticipated. The court went on to say that the uncertainty of future market prices is often, in fact, the reason for entering into a long-term contract. So now we fast forward to 2018, when that same Texas appellate court echoed similar themes. In TEC Almos LLC versus ConocoPhillips Company, TEC Almos failed to perform under a drilling contract and tried to invoke the force majeure clause due to a drop in oil prices. But the clause didn't mention price declines or market conditions. Instead, TEC Almos relied on a catch-all provision and argued that the market drop was unforeseeable. The district court disagreed and held that catch-all language still requires the event to be unforeseeable, and the driller did not and could not show this because market fluctuations are foreseeable as a matter of law. Moreover, in applying Texas common law, the court found that economic hardship, even severe economic hardship, is not a basis for excusing performance unless the contract says so. So again, the lesson here is straightforward. If you want price drops or market events to trigger a force majeure clause, say it explicitly in your contract. Otherwise, the courts will not do you any favors. Finally, let's look at a more recent decision from the Texas Supreme Court that tackles a different angle: whether the event being used to invoke force majeure has to actually cause the delay or inability to perform. In Point Energy Partners Permian LLC versus MRC Permian Company, MRC Permian had a lease that required continuous drilling to maintain the acreage. After completing one well in November 2016, the company had until May 21, 2017 to spud the next well. But they didn't start drilling until June 2nd, 12 days too late, because of an internal scheduling error. Upon realizing its mistake, MRC attempted to invoke the lease's force majeure clause, pointing to a 30-hour delay caused by operational issues on an unrelated well in April of 2017. MRC claimed that this delay extended the drilling deadline by 90 days, but the court rejected that argument, holding that force majeure clauses must be strictly construed based on their language, and that the event cited by MRC did not cause the missed deadline. Instead, the delay was the result of MRC's own internal scheduling error. The court emphasized the core principle of force majeure here, that force majeure can only be invoked when the event directly causes the failure to perform. Here, the clause covered delays caused by a force majeure event, but the actual delay in spudding the new well was due to MRC's scheduling error, not the unrelated operational issue. Because the force majeure clause did not apply, the lease terminated as to all non-producing acreage. To recap, Texas courts interpret force majeure clauses narrowly, and each case turns on the specific language used. Market changes and internal errors are foreseeable and not enough to excuse performance unless expressly stated in the contract. If you want out of a contract due to market volatility or operational issues, you better have planned for that when drafting your contract. If you need help drafting or interpreting force majeure clauses or enforcing the terms of your contracts, let our RNA know. We are happy to help.